Welcome back. A San Diego law firm has joined in a federal case involving the presidential election debates. It is about a rule that keeps independent and third-party candidates from appearing in the debates unless they average 15% in 5 national polls and 3 others that are considered major. And this is an issue that's attracted a number of lawsuits and protests. Critics say it's a two-party stranglehold. Well, here with us now is attorney Chad Peace. He, his brother Brett, and others are challenging that 15% rule. Thanks for joining us today.
Thanks for having me.
As I recall, it was the billionaire Ross Perot who stepped into the 1992 presidential election, and we did hear his voice, but since then that has not happened. The stranglehold, people are saying, well, if you just are polling at 15%, what's the grand scheme here in just coming and getting your voice into it?
Well, there's 2 real issues.
Okay.
Most people don't realize is that Ross Perot was only polling at 8% at the same time the CPD at that time. He ended up getting 17% in the election.
Okay.
But the larger question we have to ask, whether we're talking about an election process or the presidential debates, is what's the purpose of discussion? Okay. Is it to determine who of the 2 people that we pick might win a general election? Or is it to have a conversation with the American people about different issues and ideas? Now, it's no secret that both the Republican Party and the Democratic Party, for example, adopted ideas that Ross Perot first introduced into the debate, and his focus on the debt and those kinds of things. It's the debate, it's the discussion of different ideas that, whether they're incorporated through the 2 major parties. I mean, the right to women's vote was first introduced by the Socialist Party. Abraham Lincoln actually ran as a third party at the time, the Republican Party, then they became a major party. So the point of the lawsuit is, we're putting rules that are really designed by the 2 parties themselves. What people other thing that people don't realize is that the CPD is actually a partnership between 3 Democrats and 3 Republicans, and then they initiate the rules that determine who gets to talk to the American people in the most important political conversation.
Commission on Presidential Debates, and then you got the Federal Election Commission. It does sound like a closed circuit there.
Right. So really, there's 2 main points in the lawsuit. One's challenging the rule itself, that the 15% rule is unreasonable. It comes after a year-long primary process where the entire national media is focused on the Democratic and Republican nominees, and then they say, well, if anybody else can get 15% approval in a national poll, well, you can come into the debates too. Well, we all know how much money it would take to build that much name ID. The other interesting aspect of the case is the nonprofit tax deductible status of the commission itself, right? Nonpartisan does not mean bipartisan.
Okay.
But but the Commission on Presidential Debates was transparently created as a partnership between the Republican and the Democratic Party.
Okay.
So the challenge isn't a challenge to the parties themselves. It's a challenge, it's to one rule and one commission that is an example of things going on all over the country, which is a body of laws and rules that really restrict the competition, not only at the ballot box, but also the competition in ideas. And I think that's why we have a 2-sided superficial debate in this country on almost every issue, because alternative ideas that don't fit within the box just simply get shut out.
Get pushed down.
Right.
When we talk about this emanates from the lawsuit first being filed 3 years ago. Yours is a friend of the court in the Federal District of Washington.
Right.
And now it's finally getting closer to where it can really run the race in court, because you think it's never been given a fair chance, because the commission just looks at it going, why even read this?
Right.
Kick it right out.
Yeah. Well, a lot of people, they talk to me about election. Why don't we just change the rules? Why don't we just make it more fair? Because the constructs of the entire system make it extraordinarily difficult. For example, in order to challenge the CPD's rule, the challenge had to be first made in an administrative court. Now, anybody who thinks that the bureaucracy of the government is difficult to get through can imagine how difficult and how seriously they took a challenge to the bureaucracy itself. So that entire suit had to go through the administrative courts. Only after they exhausted every potential remedy in the administrative court were they then allowed to go into the District Columbia and file in a state court. So now when they file in the state court, the judge had to see the case and basically rule that that administrative court was so arbitrary and capricious and dismissed that case without really looking at it that now we'll consider it. So imagine the amount of legal time, the dollars that had to be spent to fight a lawsuit, and there's no, what's the self-interest in somebody putting all that money into it? It's seeing a better, more robust political dialogue.
Best case scenario, when do you see this getting before the federal district judge and saying, Your Honor, here it is, and the oral arguments begin?
Well, it's at actually an interesting place. The federal district court judge has already recognized once that there's some legitimate grievances,
Okay.
and that the FEC and the CPD didn't really do their job in really considering them.
Mm-hmm.
So this is really like round 2 in the
Okay.
state court. And actually today the FEC has to file a response to a summary judgment motion made
Okay.
by the level the playing field. Next month will be a critical time in the case. That's when the judge is really going to say, you know, I've looked at this, you've had a chance to come back and review this again and really determine, did the CPD and the FEC, the Federal Election Commission that governs them, did they really do their job, and are they really trying to judge this case fairly, or just protecting this whatever self-interest they might have in the case?
Okay, slowly but hopefully surely from your point of view. Thanks
Right.
again for joining us, attorney Chad Peace. And